Whenever you are ready, Mr. Cornbrat.
May it please the court, my name is Brian Cornbrath. I represent the defendant Ronnie Belt. The facts in this particular case are not contested. I think the parties agree. It was April 3rd, 2013. The West Virginia State Police received an anonymous tip from a female. The female indicated that Ronnie Belt was either using or manufacturing methamphetamine at his residence in Camden on Gauley in West Virginia. 3 West Virginia State Troopers, Dornberg, Blake, and Beyer, went over to the residence. They were in uniform. There was at least 2 cruisers. When they got to the residence, well away from the residence, arguably outside the curtilage of the residence itself, in the yard by a 4-wheeler, was a young boy, looked to be between 10 and 12 years old. Later, the law enforcement found out he was 11 years old. They confirmed that this was the Belt residence. The child indicated, yes, it is. Ronnie Belt's my dad. While Trooper Dornberg could not remember the exact words, he believes the child said, my dad's inside, come on in. When the police entered the home and requested permission to search the residence, Ronnie Belt refused. However, he was questioned by law enforcement, and that information was used to obtain a search warrant, which proved up the shake and bake methamphetamine production. When I prepared for oral argument and looked at the briefs again, I really think I put the cart before the horse, because there's a 2-step process in this particular legal analysis. You first have to decide whether there's a parent or actual authority, and then you get to consent. My brief starts out with consent, but with the court's permission, I'd like to touch upon a parent or actual authority. It's important because this court has not decided the issue. Every circuit, though, that has decided the issue has fact patterns where the minor at issue answers the door on a knock. And that's really important. When law enforcement approaches a door, they don't know whether it's the right residence. They don't know whether the target of the investigation is going to answer the door. If someone else answers the door, they have to find out who that person is, and that person may allow them into the home.
Mr. Cornbrat, if we agree with you that, well, let's assume that the entry was in violation of the Fourth Amendment. Let's just assume that. Okay. Don't we then have to come to terms with our opinion in Sedman, where on very similar facts, the court found the purge of any initial taint by virtue of attenuation, and the factors that we looked at in that opinion seem to track those here. No overt police coercion, almost, let's see, there wasn't a significant passage of time, right, but Mr. Sedman motioned the police in, and Mr. Sedman indicated a willingness to engage in a conversation and did not ask the officers to leave. The facts of Sedman look very like, at least to me, the facts here. So could you help me distinguish that case, assuming that we agree with you on the initial violation?
Well, I think one important point, though, is that in this case, before questioning even began, they asked for consent to search. And here, Belt clearly said, no, I refuse to give you consent to search. So I think that's important.
But then he also didn't. I mean, when they came in the house, he didn't say, what are you doing here?
No. No, he didn't. He didn't.
So how does that impact?
It just shows a reticence on Belt's part to fully cooperate with the authorities. But when the consent,
unfortunately for him,
I know.
He then did.
I know. He capitulated.
Cooperate.
He did to a point. He answered questions. It was rather vague. What are you worried about? A couple jars, that stuff, and that was about it. But it was enough for them to get a warrant.
Well, he engaged what the court to a considerable extent, based its discussion on in Sedman was the fact that he engaged in a conversation with the officers.
And that happened here too. But I mean, it's pretty clear that but for the entry, the conversation would not have taken place. I think that's our strongest argument.
Right, and I'm perfectly happy to give you that.
Okay.
The entrance was invalid. My only concern is what our case law seems to indicate establishes attenuation.
My understanding is the case, if it was discovered by exploiting an illegal search, derivative evidence has to be, not necessarily is one derived from the other, but is there a nexus, if you will, between the illegality and the evidence itself under the fruits of the poisonous tree doctrine. So that's the most we could hope for, that it's not attenuated. It's immediately after the entry that the court is under this fact pattern, assuming it was illegal. And again, we can't argue that it wasn't a voluntary process. They didn't berate him. They didn't coerce anything out of him.
And I think your argument is a good one. I'm having difficulty with the language. Almost immediately after Shoup entered the home, any taint arising from the entry was attenuated by Sedman's consent to the conversation. That's a pretty...
I apologize. Can you spell Sedman?
I may be mispronouncing.
That's fine.
Seidman.
I apologize to the court. I'm not familiar with the Fourth
no,
Circuit fact pattern, but
no, I'm just telling you
right. It does sound quite on point in the sense that there was little or no time before the officers went in. In that case, it was deemed illegal. The most I can say is that I think in our case, the fact that he's saying, no, I'm not going to give you consent.
Okay.
Right. Yeah, so they have to go down a different road, and they did it in this case quickly thereafter. Does the court wish to hear on the consent issue, or?
Yeah, I think it's important for you to go to the consent issue,
okay,
because I think we also have to look at Sedman in light of our case of Gooding too.
I think the Sanchez case out of the 10th Circuit is instructive. That's where the 15-year-old girl was home alone babysitting when the law enforcement knocked on the door and she allowed entry. In that particular case...
so the Supreme Court in Matlock has said a third party can.
Oh, sure. But it has to be either actual, which is mutual use or joint access, or apparent authority. Is it reasonably objective for the officers to believe that this person can go in there? And that's where we have problems, because under either the actual or the apparent authority test, assumption of risk is important. If Ronnie Belt's child answered that door, he assumed the risk, and the officers didn't know who was inside before they knocked. This case is an outlier in every other case when it comes to children, because the officers confirmed before they reached the door that Belt was home. Belt was available to answer the door if he chose to, and rather than go to the door and deal with the adult, they relied on the child. We do argue in our brief that the district court paid scant attention, if any, to the child himself, the age of the child, maturity of the child, sophistication of the child. All of those were never brought out on the record. And our West Virginia State Police officers, they're an impressive lot. But, forest green uniforms, starch uniforms, 45 caliber pistols, an 11-year-old boy, and not one, not two, but three troopers standing by him. We argue that consent was pretty much a foregone conclusion. Unless the court has any other questions.
Thank you very much. You have some time for rebuttal.
Thank you.
Mr. Warner.
Thank you. Good morning, and may it please the court. I am Stephen Warner from the Northern District of West Virginia, and Assistant U.S. Attorney stationed in Elkins. We argue that the district court did not clearly err in finding that the defendant's son had the authority to consent to police entry of his home, and that the district court did not clearly err in finding that the defendant's son did so voluntarily, because the district court did that test based on the totality of the circumstances. I agree with Mr. Cornbreath that we found no Fourth Circuit case that decided the issue whether an 11-year-old boy can consent to entry of a home. But I ask the court that we don't need a new rule on the subject because the totality of the circumstances test is a long-standing and well-founded rule across the country and in the Supreme Court. Other circuits have looked at it.
Where would this lead us if we go in the direction of where you're going with this? Well, you have officers who receive a tip that the defendant is in this home manufacturing drugs or doing whatever, and they approach this house ostensibly just to talk to him. But clearly they don't just want to talk to him, they really want to get in his house, but be that as it may. And they see a child, clearly a child, playing in the yard. And the child says, come in. And they just walk in. And it would seem to me at that point, I mean, where does that lead us? I mean, and the reason I ask you that is I can very well see even an extension of Matlock, maybe even an extension in terms of authority, maybe even going with the Sedman about the taint business, but we got the Gooding case that I think backtracks that a little bit, and then the question of whether how much was this voluntary after you got in the house, how much did he come forth with it, and under what circumstances, because he initially said, no, you can't be here, that whole bit. I'm just wondering, where is it going to lead us? I mean, in civil and criminal cases, when I think about the fact that a child is in the yard, why would a police officer do anything other than that? If they want to get in the house, go there, wait till you see a child in the yard, and if the child beckons you to come in, walk in. Then everything in plain view is in order, and if the person in the house then opens up, we can say Sedman says no taint. Is that where we're headed? Or is that where we are?
Judge, first of all, if I could say I respectfully disagree with some of your interpretation of the facts of this case. I know the child's an 11-year-old boy, and I respect that. It is it's an 11-year-old.
Tell me what
I don't
you
mean
disagree with. I want to know
Okay.
specifically which facts are you disagreeing with.
You said the phrase playing in the yard. The evidence was he was in an all-terrain vehicle in the yard.
They
He
call it
wasn't
a four-wheeler
playing.
or something. I had a little time trying to figure out what that is, but
That's a motor vehicle.
You're out there on a four-wheeler. Is this out in the country?
This is West Virginia, Judge, and
Yeah, that's
I'll
what
do
I
that.
thought. Everybody's got a four-wheeler.
All of our 11-year-olds
Those
have
things are like
four-wheelers.
big wheels to those guys out there.
Just a minute. Do you have anything to say about that characterization?
I think he's probably right about that.
But I would
can tell you it probably is true in Eastern North Carolina too. It's spots where I'm from. But
I
be
would
that as it may, that can't turn anything. The fact that he's on ATV. Are you saying he's more mature because of that?
Well, I'm saying it's with the totality of the circumstances test for the district court to assess, because at least 4 other circuits have found that a juvenile can consent. The district court in this case didn't. There's not a lot of facts on the record, but when you look
Juvenile that's already in the house, the other circuits, not out
But-
in the yard. They don't even know really that the juvenile resides there. They know his father resides there. He says, this is my father's house, but you don't know, because he's out in the yard. They don't know whether he resides there or not. He could just be visiting for the weekend. And how is it reasonable for an officer to to think that it's okay to just walk in somebody's house because a child that they thought looked 10 years old said it was okay, come in. Certainly, if it was that officer's child, they wouldn't be telling them it's okay to tell people to just come in the house.
Well, respectfully, Judge, it's not that different from the knock on the door, because the knock on the door cases, when the door opens, the police see the child and come in the house nonetheless. I would argue that's no different than the child bringing the police into the house. Either way, they know it's a child who permitted entrance. So I argue that those...
Well, first, those circuit cases aren't binding on us.
Yes, sir.
But I'm not so sure they aren't distinguishable in some other facets. You've got at least one of the cases I remember, there was a 14-year-old there. They were home by themselves, kind of in control. I don't know if we need to go there. I'm just dealing with a kid out in the yard. 10-year-old, 10, 11-year-old kid playing in the yard. Officers come up. They want to go in this house because that's what they got the tips for. There's something going on in this house, and the kid said, come in. They just walk in. They don't say to the kid, go get dad, bring him to the door. That frightens me. The fact that my kid could be out in the front, and I fortunately don't have a kid that young anymore, thank you, but it could be a grandkid, out in the front playing, he just come in. Or it could have been a neighbor's kid who just happens to come in the house a lot. That happens in Eastern North Carolina, probably happens in West Virginia. Neighbors sort of running out of the house the whole time. The kid said, oh yeah, he's inside, come on in. and you walk in.
It certainly wouldn't be what officers would instruct their own children to do, or what officers probably regularly instruct school children to do. Don't let people in the house without seeking your parents' permission.
But Judge, if I could, going back to the facts, I respect the youth. I'm not trying to argue, except that this spills into the attenuation issue. The fact that the officers, once in the house, did nothing but go directly to the defendant and speak to him and did nothing else, even though 3 officers are in this person's house. If they wanted to get in the house to search, they were in the house.
House is pretty sacred from my
Excuse me?
perspective. I mean, to walk in a person's house, I mean, that's big stuff. You don't just walk in the house. You got a kid out in the yard. Why? If you want to speak to the dad, go get dad. Tell him to come to the door. Maybe something happens if that doesn't happen, but at least take some step before just walking into someone's home. People run around in their house naked. They do all kinds of stuff in the house. They don't expect to look around and see that a 10 or 11-year-old kid has brought, police officers have followed a 10 or 11-year-old kid into a house. Can an ordinary citizen do it? Can someone on the street walk in and say to a 10-year-old, Mom, Dad in, and just walk in? Of course, there's no Fourth Amendment violation, but there seems to be something wrong with that. I mean, is there going to be a liability? He had consent to bring you in my house. I mean, it's troubling. It's troubling from a civil perspective. And I know in most states in civil law, a child under 7 cannot be negligent. 7 to 14 is a presumptive cannot be. So there's a diminished level of capacity somewhere in there. Police officers know this, and it just seems reasonable. We're not trying to keep a police officer doing his job. It just seems reasonable. Just go ask Dad. It sounds like if you'd asked the dad to come to the door, he was going to tell him anyway. I mean, this is not, I won't characterize the defendant in this case, but he did make some pretty forthright statements.
Well, Judge, I would just ask that it seems like the line of cases throughout the country are that it's a totality of the circumstances test, best left for the district court. It was able to assess the demeanor of the witnesses who testified, in this case, the 2 officers. And after the magistrate judge...
That's probably where I differ a little bit. I totally agree, totality of the circumstances, but it does not ignore the officers. It does not ignore that in that totality of circumstances, it has to do with common sense and reasonableness and what's good. I mean, here you got a person who's actually doing something in the house, but in the vast majority of people, they're just in their home living. They don't expect a 10, 11-year-old kid, officers to follow them into the house, walk through the house, not just go to the door and yell out, is anyone home, or knock on the door. Just walk on in behind a 10-year-old kid, 11-year-old kid. Is that where we are now?
But Judge, the strange thing about this case then is that the defendant, and I think it's a finding below, that the defendant himself didn't say or do anything to indicate that he had any objection to the 11-year-old boy letting the police into his house. Some parents might have such an objection, and you would hear it, but in this case, it seemed, as you read the transcript and listen to the testimony, almost normal. If you remove...
He didn't have a chance. By then, they're already in the house. What good is it going to do to say, I object to bringing them in here? I mean, what is that, an after fact? I didn't like the fact he did that. He's already done it. And he asked him, maybe asked him in the beginning, says, would you like for officers to walk in your house if your 10-year-old, 11-year-old son is playing out in the yard? He's probably going to say no. So he didn't exactly have a fair chance to address that. I'm not sure that should be held against him. But
I don't know if I could get too much further on this argument with you, Judge. I respect your opinion, and I just would ask that you...
Well, you can, I mean, for whatever it's worth, you can make the argument that he didn't ask the man to leave. I think you have to acknowledge that there's a problem with getting into the house. The facts here are that it seemed to have unfolded so quickly. The child, as I understand the facts, just said, come on in. And they just followed him in.
Yes, ma'am.
And it certainly would have been better for them to say, police officers entering your home. I mean, I would be pretty terrified to look up and find 3 police officers walking into my kitchen. I mean, certainly there were better ways to go about this. I think you have to agree with that. Or do you not?
I think they could have knocked on the door and waited for the dad to come. Yes, ma'am. But the phrase, better ways gets close to the area of
I do
attenuation.
and I completely understand your point. I just think you take the expressed concern that you've heard as well.
Judge, I was also interested, though, when I looked at 4 other circuits, the 10th, 11th, 6th, and 9th, and they found that even opening the door, and Mr. Cornbreath tried to make a distinction, and maybe he has, between opening the door and following the boy in. But in any case, the police know a child is letting them in the house. So why would 4 other circuits permit this? Why would 4 other circuits permit it? So I read the case law, and I see that other circuits are permitting it. The test is totality, and I just ask that you let that decision be made by the district court. Incidentally, I did note in the district court order that is at issue here today that the district court did set out the totality of the circumstances test and listed factors to consider. I actually counted 15 factors the court listed that it was going to consider in this fairly short order, but it listed 15 factors, and it did go through them. So I would ask that you...
Tell me about the 4 circuits that allow this. What are the cases you point to?
Yes, sir. In the 10th Circuit, 14-year-old daughter in the case of...
Case are we talking?
Gutierrez, her two-word case. The first word is Gutierrez. Also the 10th Circuit in the case of Sanchez, 15-year-old babysitter. In the 11th Circuit...
15-year-old babysitter?
Yes, sir.
Sitting in the house?
Yes, sir.
Okay. Not 11-year-old child in the yard?
I respect.
Okay.
In the 11th Circuit, it was a 9-year-old.
Babysitter who's home by herself, by the way.
I don't recall the facts if the babysitter the child was there or not.
What's the next circuit?
11th Circuit has the case of Lentz, Lenz, that is cited in the record. That's where a 9-year-old lets the police in with a guardian ad litem who has been appointed to the 9-year-old. The 6th Circuit allowed consent by a 12-year-old and 14-year-olds in the case of Clutter, the 2 boys together. And the 9th Circuit, in the case of Davis, is actually fairly similar to ours today, where an 8-year-old, the police went to the house just to do a knock and talk, and the 8-year-old let them in. That's actually very similar facts, and the district court, in our case, did rely on Davis in its order that's on issue today. So that's 4 other circuits as I looked at the law in assessing what the district court did in our case.
Well, I won't go through each one of them, but there are some distinguishing facts in each one of those cases. And I'm not sure they're material in terms of the difference here. But, it may well be that in the instance of maybe the Georgia case where they say, okay, it's coming, where you would think a salesman or someone else can walk in, you can come into that area. But this is the kid who leads officers, uniformed officers, and it is frightening to think about that possibility. We want to get criminal conduct. But there's just a way to do it. And it just seems like to me there are ways less invasive to the average citizen and to the notions of the Fourth Amendment, other than just how many officers?
3.
3 uniformed officers.
Yes, sir.
Following a child into the bowels of a home, right to the father. Frightening to me. Legal arguments notwithstanding, I understand the court could go differently on it. I'll think about it. I'm not saying I'm locked on it, but I'm troubled by it.
I hope you would reaffirm the totality of the circumstances test and let that age be a factor for the district court below to consider.
Well,
why
I
would
will
the government
definitely accept the totality of the circumstances test. That's just the law.
Yes,
but I'm not so sure it compels this result.
Yes, ma'am.
Yeah, and why would the government be, in my view, really pushing boundaries here of what's appropriate, and just accept, as Judge Duncan said, that's not a good policy, and argue attenuation?
Judge, I do argue attenuation. It's in my brief, and we've spent too much time already on consent. I do, and I hope I haven't diminished my argument on attenuation.
Because you
getting involved.
do keep resisting the acknowledging that this is not good, and the government did spend a lot of time in its brief, and maybe in response to appellant's brief, but in your argument, pushing this, it's okay to follow a 10-year-old into a house or 11-year-old.
Well, I don't think I only
I
spent
think
time.
your attenuation argument is a good one.
Thank you, Judge. And I only spent time because I think it may be the most difficult argument. I hope it doesn't diminish my attenuation case.
No, I think, I certainly didn't mean to criticize your argument. For me, it would have gone over a little better if you would have acknowledged the concerns that were unanimously articulated.
I hear you.
That was my only point, and I certainly didn't mean to prejudge the disposition of the appeal.
Well, Judge, I'm a father too, and I was a little, I saw the other circuits, and the other circuits have permitted entry by a child, and I couldn't find any circuit that said you can't.
I think we understand that point, and you just won't let it go.
Thank you.
Thank you.
In defendant's brief at pages 8, 9, and 10, we do distinguish the other cases across the country. And they're important distinctions because in every case, the juvenile is answering the door. And that's important, again, for two reasons. It shows the officers that this young person has joint access, mutual use of the property because he or she's answering the door.
Could I ask about that, though? And maybe I'm not remembering the facts, but I thought that the child here led the officers in. So presumably the child here had access as well.
Yes, in the sense that, come on, follow me.
But is my recollection correct that he led them into the house?
Yes, he led them into the house, right. But what's also important here, too, though, is before he said, follow me, come on in, before he even said that, he said, yes, my dad's inside. And that's where we try to draw a distinction with the other cases. When the officer's knocking on the door, they don't know who's going to answer the door or what that person's connection is to the property.
And actually, it would have made more sense for the officers to knock just from the standpoint of what might have occurred on the other side of the door. I think there's the
even better procedure would be once the child says, my dad's inside, you know it's the right home and you know the adult's there, you bypass the juvenile because he wasn't.
That was what I was saying in my hypothetical, that you just go to the door independently.
So I think this is an important distinction in the sense that the officers have no uncertainty when they're well outside the home. They know the adult's present, and they know they could go directly to deal with the adult. I know hours from now when myself and Mr. Warner get back to the office, we're going to read Sedman, him with relish and me with trepidation. But when it comes to the attenuation doctrine, I just want to point out that one of the factors this court cited in U.S. versus Gaines, a 2012 published case, was the purpose of the flagrancy of the official misconduct. So, to the extent you think that the officers crossed the line, that's an important factor that you can.
Read while you have to read Sedman too, because we also have that case that came after them.
All right.
And I think one of the issues that we've not touched on, and I think is so important, is this is an 11-year-old child. It could have been a 4-year-old child, a 5-year-old child that's particularly bright to do the same thing. Go through the same analysis and say, well, does a child appear to have, which we didn't do, we didn't go into the capacity of the child, the knowledge of it. We just know it's a child.
That's correct.
And it didn't have to be 11. Could have been 8. And some places, could have been 6. Could have been 4. I don't know. But it's a frightening situation what we have here that officers, and that's why I go back to this thing here. End of the day, it is 3 uniformed officers with a specific purpose, and they're not just coming up to try to get you in the fraternal order of the police contribution or something like that. They are coming up to do something to this father and to try to get him incriminated, and they do it with this kid in the yard. Now, whatever the law may be on that for attenuating circumstances, the fact of the matter is the way they got there was to use that child to get to it.
And it was the child, again,
And that
in the
may-
yard.
That may well be at the end of the day the way it's going to write, but it does not write very well the other way either.
But, excuse me, maybe I misunderstood. In Stedman, the court said there's a Fourth Amendment violation, assumed that there was a Fourth Amendment violation.
But
The
in-
question of attenuation arose
Right.
because the court had found the initial violation.
I guess I'm talking about degree, flagrancy.
Right, and that was
yeah.
one of the
That's true too
factors.
in good.
Yeah,
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 The court found there was a violation in
Yeah.
that suitcase initially, and then they say no.
right,
That same situation.
right. So I think the flagrancy matters here.
Yes.
Again, it's a child, I'm sorry, my time's up. It's a child in the yard. There was no assumption of risk. He didn't answer the door.
thank you. Mr. Warner,
Oh, I'm sorry, thank you.
you didn't cross appeal, did you? Was there? Okay, thank you. Did you have so much fun you just had to come?
Oh, yeah.
Okay. Thank you very much. We will come down and greet counsel for one break. And go directly to our last case.